Good evening. This is the Monroe Township Public Hearing, January 2022 of 25, opening ceremonies. Call to order. This public hearing, appeal to council, was called pursuant to the provisions of the Open Public Meetings Law. Notices of this meeting were sent to the Courier Post and the Sentinel of the Gloucester County on January 15th, 2025. In addition, copies of notices were posted on the bulletin board in the municipal building and filed in the office of the municipal clerk, and aforementioned date, notices on the bulletin board have remained continuously posted. Please note that the clerk has placed a sign-in sheet in the rear of the courtroom. If anyone would like to address council during the public portion, please sign in, raise your hand, and I will ask you to come forward to the microphone. Kindly state your name and address for the record. In addition, please note that the audio and video of this meeting is being recorded in accordance with Ordinance 56-2024. A copy of this recording will be posted on the township's website for the public to view at their convenience. Please all rise for the flag salute led by Councilman Rossi.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
This public hearing appeal is for major capital improvements, increased application for Friendly Village. Do I have a motion to open public portion for the resolution scheduled?
Motion.
Should we do roll call or no?
Oh, yeah, we can do a roll call. Go ahead.
Council Vice President, Mrs. Adams. Here. Mr. Cope.
Here.
Mrs. Fox. Here. Council President, Mr. Heverly.
Here.
Mr. Riley.
Here.
Mr. Rossi.
Here.
Mr. Valentine is excused. Mayor Wolf.
Here.
Deputy Mayor Kurz is excused. Solicitor, Mrs. Grace.
Present.
And Business Administrator, Mr. Dehart.
Here.
And myself, Municipal Clerk Eileen Chiselko, and all directors have been excused from this meeting.
Thank you. Do I have a motion to open public portion for a resolution scheduled?
Motion.
Second.
All in favor?
Aye.
Opposed? Anyone wishing to speak on resolution scheduled? Seeing none, do I have a motion to close public portion?
Motion.
Second.
All in favor?
Aye.
Opposed? Resolutions. Resolution 77-2025, a resolution authorizing closed executive session of the Township Council of the Township of Monroe to discuss matters falling under pending and anticipated litigation subject to attorney-client privilege pursuant to NJSA 10:4-12B. Do I have a motion to approve?
Motion.
Second.
All in favor?
Aye.
Opposed? At this time, council will hold a closed meeting, but the public will be excluded. Council will reopen to the public to advise of any action taken. Thank you.
Going into closed session to discuss this appeal.
Why can't I?
That's a violation of the Open Public Records.
How is that?
Because it's a pending administrative proceeding. Every administrative proceeding before every body's anticipated litigation. But just because we've appealed here, there's case law on this. When you're sitting in administrative capacity, which is what you're doing to hear this appeal, you can't go behind closed doors. All deliberations have to be in public. I don't have a case.
My recommendations to council have to be in public? That's under B7.
Well, there's no difference between your role as the attorney to this governing body for this proceeding and the attorney's role for the planning board or zoning board. They can't go behind closed doors and discuss a pending application. If there's a decision, someone takes it to the Superior Court, now it fits under the litigation section. But there's no appeal to the Superior Court yet. The litigation section.
But B7 applies to not just solely pending or anticipated litigation, it applies to matters which require the attorney to do their job.
Not administrative matters.
Do you have the case law?
Closed session during, I do.
Can I have it?
I don't have the case in my hand. However, I've litigated this. I know there's a case. I know the judge wrote it, Judge Guccio, 78 or 9, and it deals with administrative agencies. Until the decision is made, there's an appeal. All deliberations have to be.
But it's not deliberations.
What?
It is not deliberations.
What deliberations? Yeah, it is.
It is me providing advice to council members under B7.
And again, your right to give them advice is the same as the planning board's attorney, to give them advice, or the zoning board, or release it as the rent board attorney in the middle of the hearing. It can't be behind closed doors.
But we haven't started the hearing.
You can't discuss the matter, or you can't go behind.
How is this any different than if I would have discussed it in executive session that was called before?
It would have been illegal. I don't know what you're discussing back there, but it's clear the way this has evolved this evening. But the only reason the council is still convened is to address my appeal.
Well, to be honest with you, I actually have other matters to discuss with one or two other options. So we do have to go into closed
That's
session.
why I asked the question.
Correct, okay. But,
My my objection on the record, please
Sure.
don't discuss my appeal behind closed doors.
sure,
Thank you.
no problem. If you can, I don't know if you have any associate that's on right now to send me that case law, please, I'd greatly appreciate it.
Yeah.
Well, I'm working.
I wish all my associates had work meetings.
Okay, calling the meeting back to order. Comments from our solicitor?
Yes, let me just let the record reflect that we just retreated to executive session to discuss two pending presently litigation matters and not this appeal. Just let the record reflect that. Thank you.
All right, moving on to the address of the appeal for comments.
Mr. Hanlon, floor is yours.
Thank you. Is it on? Yes? Okay? Everybody hear me?
Sir.
Good evening. My name is Christopher Hanlon. I'm with the law firm of Hanlon, Neiman and Wright. I'm representing Friendly Village of Williamstown. I'm here tonight to pursue an appeal that we filed pursuant to the terms of your rent control ordinance as a result of a decision made by the rent board last September concerning a capital improvement increase that we submitted, asking for approval from the board for a monthly increase of $12.69 per month per site, based on $835,962 in capital improvements my client had made before we filed the application. More specifically, my client made all of these improvements before rent control was imposed. So we submit that should have been considered favorably by the board because it was really part of what my client thought was a good faith operation of that investment, which is a significant investment. As you all know, there's 562 sites there, I believe. And as indicated, all of these improvements were made before the rent control was even an issue. So this no one could even think that we're doing it to justify rent increases under your rent control ordinance. We're doing it in the normal course of our business. Before I jump into a little more numbers, it's my understanding that what we're doing here tonight is called a de novo review. So because of the way you drafted your ordinance, if we want to challenge what the rent board decides, we have to come here first before we go to court, and hopefully we don't go to court. When we come here, you don't have to defer to any of their decision-making. You have the right to make independent assessments of the facts and apply the law as it's written, as you wrote it, to the facts that we've presented. And the facts we presented and the facts you should consider are the facts that were part of the record developed before the rent board. So that was our application with supporting documentation, some documents we submitted after the process, the give and take process with the board evolved. They wanted some more information. They wanted more justification for some of the numbers we used. And it involves the testimony that we presented to the board and that objecting tenants presented to the board at the board's meeting in August. We had the transcript of those hearings conducted. We've submitted that. That's all the record. It's my understanding you should have all reviewed it all because you're now basically sitting as the judge to decide this case. I think there are really two issues that the rent board determined, and you may find some others. You have the right to do that, but if you identify those, I'll address them. But I think that the two issues that the rent board, or that we've identified with the rent board's hearing are probably most germane, so that's what I'll try to address. I'll try to be pretty quick about it. Before we get to the two issues, if you read the decision-making of the rent board on the second meeting transcript, you'll see the rent board, guided by council, went through each of our 5 categories of capital improvements, and they made an assessment concerning whether or not there were capital expenditures, whether the expenditures that we submitted details of were verified, and whether they should be treated as capital improvements under the ordinance. And it's my understanding they agreed with all of them. The 5 categories are road repaving. My client spent $738,600 in road repaving. There was a pool renovation. It's a concrete pool. They had the entire pool resurfaced after using it for decades. That was approved by the board. They created a swale to improve drainage for stormwater runoff near common areas. That was disallowed. They changed all the lighting in the clubhouse to LED lighting, and that had to be treated as a capital expenditure. It was somewhat costly for that type of project. It was $7,332. The rent board approved that in its entirety. And they resurfaced the shuffleboard court. And many of these things, I think, are similar to projects that you undertake. Certainly the road repaving is. There's really no difference in a 562-unit mobile home park, which probably has miles of road, between their having to deal with that surface to make sure that it has integrity, it's flat, the cars don't get run over potholes, and it drains properly, same way you do when you address repaving roads in this township. 2 issues that the board identified and were the only justification for denial were the following. Your ordinance contains a provision that any invoice that's submitted in support of an application of this type can't be older than 18 months. And unfortunately, in drafting your ordinance, you've included some unfortunate language which is playing out here to be unfortunate, because it's 18 months from the date of the invoice. It's not the date of payment, not the date of completion of the project. It's the date of the invoice, and in some cases with small businessmen in some of these projects, the invoice is their proposal. So the date of the invoice is the beginning of everything that has to follow. And in the case of repaving, it really caused us some significant problems to the extent that the board disallowed $280,000 of, I want to make sure that's correct. Yes, $280,000 of our repaving project. We submitted, it was a single project. We supplied documents indicating that it started with our consulting with an engineer about it. The roads out there had a drainage system with a concrete sluice in the middle of the road. That's how stormwater drainage was handled. And after decades, I think 4 decades of that, my client decided that's not good enough. We have to improve it. We have to take that out, and we have to regrade the roads differently. And therefore, they went to an engineer. So the first thing they did to do this repaving project was consult with an engineer. That was September of 2020, in the middle of the pandemic. Then the project started, and again, the paving project was $730,000. It's considerable. There are many streets. If you look at the invoices, there's a lot of work they did, and my client explained during the hearing, before we start paving, it's our intention, we're going to mill those roads, but everything adjacent to where the new paving is going to go has to have integrity with it. Otherwise, the paving will fail. That's probably a concern that you have with your contractors when you're paving roads out in Monroe Township. And that includes any curbing that's now been deteriorated over 40 years. All has to be addressed first. All the catch basins have to be addressed. Point is, the project took about 3 years. Now, your ordinance contains contradictory language. It says if we're going to ask for the rent board to approve a capital improvement, we have to give them the quote-unquote completed cost of the improvement. And because of the timing here, when we started with our engineer in 2020 and then worked through the end of that process, by the time we were in the middle of the process, that 18-month limit you put on it, consideration of invoices, cut right in the middle of it. So that's why now the board under your ordinance has the discretion to approve invoices older than that under certain circumstances. And certainly with the paving project, we think they should have approved the whole project. They had no problem with the project being a capital improvement, being authorized under the ordinance, but they just strictly applied the 18-month limit, cut the project costs in half, and denied that $280,000. We're asking you not to do that. We're asking you to use the discretion called for under the ordinance to consider invoices that are older than 18 months for that justifiable reason. It's a project that qualifies for capital improvement treatment under the ordinance. Please approve the entire cost of the project. There were no other questions raised anywhere about the integrity and the amount of the project. No one said you spent too much, it was unreasonable, none of that. You certainly have discretion to raise those questions if you review the invoices and want to do that. But I don't think there's anything in the record to justify that. So first and foremost, we're asking you to change the decision by approving the entire repaving project. For the pool renovation, they found it was approved. It wasn't impacted by the 18 months. They approved it. We're asking you to approve it. For the swale that was created to improve the drainage, they found that all of those expenses were outside the 18 months, and that's the only reason they're not. Lighting improvements, they found that it was acceptable, it met the criteria of your ordinance for capital improvement, they approved it. We're asking you to approve it. Shuffleboard renovation, same thing, they found it qualified, otherwise qualified, but it was outside the 18 months, so it was denied in its entirety. Excuse me. You understand?
I apologize.
Sure.
You said it was paving was outside the 18 months, the pool was outside the 18 months
No,
as well?
the pool was approved in its
Okay.
entirety. I don't know if I misspoke or...
No, I probably just misheard, I apologize.
No,
I have a question with that,
So
too.
just
Paving.
to recap, pool and clubhouse light conversion, both approved in their entirety. Shuffleboard court and new drainage swale denied in their entirety, and the repaving was cut roughly in half. Again, we submitted $738,000, they approved $450,000. So by my quick math tonight, sitting here, they disallowed $280,000, and the only reason I can discern from the record is it fell outside the 18-month window. In addition to the timing issues created with the paving, which took years, this is the first application of this sort under your brand-new ordinance. And yes, the board said, well, you should have been faster, and I get that, but it takes time to figure this stuff out. Don't forget, when you passed the ordinance in September, the first thing that happened was litigation was filed by my client with another law firm. And it's my understanding that challenge is still going. The point is, when you're operating your property and you get this type of economic regulation, and your first reaction is, well, this is not constitutional, I want to challenge it, that complicates the decision-making on, well, I better get going with these capital improvement applications. And then, of course, given it's a brand-new ordinance, one has to figure out what's required, put the application together. You've seen the application, hopefully you've had it, hopefully you've read it. It's not the easiest thing to do. We asked the board to take that into consideration for the stormwater drainage. Again, a project that I'm sure they're all happy we completed out there, because that's a very important factor in, not for us, we don't live there, tenants do. And all of these things were improvements that benefit the tenants. And under a rent control scheme, which you have in place now, my client has to learn to live with it. What I do, because I represent dozens of landlords statewide, rent control towns, 30 of them, mobile home parks, statewide, and I've been doing it for 40 years. My goal is to get what I call workable rent control. You want the protections in place because you want to protect your tenants. You want to control the increases, not stop them. You can't, and I don't think you want to. But workable rent control should reward landlords who decide that they're going to spend their money on the infrastructure where the tenants live and make it better, and that's what happened here. So for those reasons, we're asking you to not use the 18-month limit as a shield. I understand it might be a shield against some type of abuse. I don't get it here. I don't understand any policy of rent control that would justify saying, no, we're not going to reward the landlord for that swale, and we're not going to reward the landlord for the renovating the shuffleboard court. The second issue.
I'm sorry, Mr. Hanlon, can we just stay on the 18-month issue for a few minutes?
We can do whatever you want.
Thank you, sir. That's like the most discretion I've ever gotten. All right, so.
I'll probably object to your question, but.
Probably, that's fine.
Just kidding.
With the understanding that some of the submitted invoices were not within that 18-month time frame, how many months had it passed, if you know?
Hold on. I have a chart for that, which we gave to the rent board, so it's part of the record. Oops. Sorry, I thought that was at my fingertips. Bear with me. So when you're saying so let me understand the nature of the question. How late were we?
Yes.
Is that the question? Hold on 1 second. Preparing for this, I wrote that down somewhere, and now I just can't find it. If I find it, I'll be real fast with the answer. No. No, and no. Okay. All right, so reconstructing it, if we filed our application on May 1st. So I believe that would be, October 30 of 22. So, anything older than, going backwards than October 30, 22 was the cutoff. Okay, because we filed our application May 1st, 24. If you go back a year, that's May 1st, 23, and then go back 6 months, that's basically, it's Halloween of 2022.
I believe it would be November 1st, 2022.
Yeah, okay, November 1st. It's not going to matter, there's no
Sure.
October 31 invoices. The shuffleboard court was paid, the final invoice paid for the shuffleboard project was in the September 26th. So we were
September 26th.
37 days there. For the paving, there's various invoices that were disallowed. One is as early as April of 2022. No, September of 2020 was when we consulted with our engineer.
Okay.
So that was 2 years at a time, if you want to split the project. But the bulk of the money was spent in September of 2022, so it would have been 17 and a half months old instead of, 19 and a half months old instead of 18 months. And
Okay.
for the drainage swale, it was July of 2022, so that means it was 4 months at a time-ish. Could have been 4.5.
Okay. And you might probably guess what my next question is, which is the rent leveling ordinance was enacted in October, right?
I think September 28th, I thought, but I'd have to double check.
Thought it was October, but I have nightmares. I have nightmares often about this.
This says 9/28.
Okay.
20.
So, I mean, okay, give it the 20 days, right?
Right, okay.
So in October of 2023, right? If
Right.
we get the allotted 20
Okay.
days. This application didn't come before the rent leveling board until May of 2024. Were there any invoices that were excluded based on this 18 months limit that had the application been filed prior to prior to May of 2024, that they would have been included had the application been filed earlier than May?
Yes.
Okay,
So we filed sooner, the 18 months
sure.
would have been pushed back. And if we file, I think the facts are, if we filed 2 months sooner, we would have caught most of
Sure.
not all of the paving expenses, but probably six figures of the paving expenses was expended in September of 2022.
Okay, so technically speaking, would you agree with me if the application had been filed sooner, the 18-month limit would have still allowed a significant amount of renovations?
It was, but it still would have split the paving project, which makes no sense. And especially since what you're excluding is the expenses that everyone in the room would say were really reasonable for the landlord to include, which is the consultation with the engineer. And that occurred during COVID, and then we hit the winter. So and again, in addition to the problems I alluded to about paving, the other problem with paving projects is the weather. And that slows, I'm sure it slows you down. Maybe I'm being presumptuous and I'm wrong, but my experience with mobile home parks, representing them for 40 years, is that paving projects are based on numerous things, not the least of which is we can't ask everybody to move out while we do it. Every day we're trying to do the project, people are coming and going home from work. They live there. There's action there. There's probably school buses and children in there. And then, of course, there's the weather. So could we have been faster under the perfect situation? Yes, we could have been. I can't say it was impossible to do it. I'm just saying under the circumstances, the delay had really nothing to do with the policies which support this ordinance, which is to protect the tenants from abuse. And especially when you're talking about a single project and your ordinance says that's what we should be considering the completed cost of the capital improvement, because we shouldn't be running in with, for example, if we're doing a paving project, we're halfway through, should we run, we're now forced under the way your ordinance is drafted to run into the board and ask for them to approve a half-baked project, or we just can't get it ever. Who intended that result? Nobody. So respectfully, I'm not, I'm criticizing you, but I'm not criticizing you, because you don't live with rent control, so nobody knows about rent control until you do. To have an 18-month limit starting from the date of the invoice doesn't work. It's not workable. It's not fair to anybody, especially if you're talking about a big project. And so why do it unless you're just trying to stick your tongue out at the landlord and say, you can't get this money, and that's not your purpose. Your purpose is to protect your residents. And again, you protect your residents by two things: limiting rent increases to those that are reasonable, but also allowing the landlord to operate the way you want them to operate. You want them to make these improvements. There's no doubt about it. I've never heard any tenant advocate ever say, no, we don't. We don't want you to repave the system. Of course you do. So make it workable. That's our only point.
I have a question.
Sure.
This is not about timelines or anything like that, so if you want to finish that.
Yes, please.
Okay.
What is the amount that was denied based on the 2020 invoices?
You mean the engineer?
Correct. The consulting fees that you've been discussing.
That's $600. It's not much.
Okay.
Again, it's part of the complete project. So
Sure.
the next one, the expenditure in April of 2022. So the start of, really rolling up our sleeves and starting the pavement project, which was April of 2022, is $50,000.
Which, I want to reiterate again, April 2022, 18 months from that would have been sometime in October of 2023, after the enactment of the ordinance.
Maybe like 4, yeah.
Okay.
We would have had to
And you were aware of the
We would have to
ordinance.
file the application before the effective date of the ordinance.
You would agree with me that you were aware of the ordinance? When it was-
My client was aware that it passed, but as you pointed out in correcting me on the effective date, we couldn't have filed an application for that $50,000 before the ordinance was effective. So
Sure.
first of all, why would we ever do that?
No,
Number
no,
one.
I'm not asking you
And then-
to. I'm just asking why wasn't it filed in October or November or
Well,
December?
because the project wasn't completed then.
But it's based on the invoice date, as you just indicated.
Exactly.
Okay, so I think I'm going to just, again, ask my question. Why wasn't the application filed in October or November or December or January or February or March or April?
Because the landlord, first of all, the landlord has to hire people and get it done, That takes time. These applications don't get filed in days. It just doesn't happen. And again, if you want to take the position, I think I've already said this. Could it have happened? It probably could have. But what's the purpose in using the ordinance in this fashion? I think it's unreasonable, and it's inconsistent with the public policy. Again, the public policy is to encourage landlords to make capital improvements, and here you had a guy who decided to do it before he even knew there was some remuneration benefit under your ordinance. When he decided to make these improvements, the ordinance didn't even exist. So, all he was up to was managing the property and then dealing with its infrastructure in the proper way. And that project didn't get completed until a date when the older invoices couldn't have been included. So, for that reason, we're requesting you to decide that issue differently.
Do you have a question on the
I did.
18 months?
No. I had a question about, you had said that these were good faith improvements by the landlord. And I think you said that the roads, was it 4 decades of, the roads were 4 decades of disrepair?
His testimony was that they were probably 40 years old. He also elaborated on his treatment of them in the interim, which was that they were slurried and addressed with crack fill on numerous occasions in the past. But then by 2020, the decision was made, that's not working anymore. We have to do a repaving project, and that was undertaken. There's nothing in the record to suggest that that was too late, or he waited too long, or he should have done it sooner, or anything of that nature.
There's not, okay.
And again, the decision-making related to doing it was made before this ordinance was even an idea in anyone's brain. Nobody thought rent control was coming to Monroe Township in 2020.
But just a question on clarification. You said the shuffleboard court, did I get that right? That was September 26th of 2024?
Shuffleboard court was completed in October of 2022. I'm sorry, the invoice date is 9/26/22. That's right.
22.
Yes.
Right, so, 13 months after that, this ordinance was in place, correct?
It was in place 13 months, exactly.
Right, so I guess to our solicitor's point, if you filed the shuffleboard court, which you're appealing, 2 months prior, this wouldn't have been an issue, correct? Do I have my timeline right, correct with that?
Well, the first invoice for the shuffleboard court was 6/29/22. So that would have been, the deadline
You
for
said
filing
September.
that would have been December of '23. So that's correct. If my client basically got it filed within 45 days after passage, that one,
That would have been in the
Would not have
timeframe.
been
If he
impacted.
filed it in sooner, it would have been in the timeframe from
That's
the
right.
ordinance that was
Correct.
passed.
That's
So
correct.
the 18 months is feasible.
Yes, it was feasible.
Okay. Same question with the drainage. Can I have that date again for the swell?
July 10th, 22. So the 18 months there would have been, I guess, January 10th.
That would have worked, though.
January 10th, 24.
Yeah, so the drainage would have worked as well.
That's correct.
And how much was unpaid for the paving?
How much was disallowed?
Yes.
Oops, sorry. $280,104.66.
280.
$280,104.66. Any other questions on the 18-month issue? Second issue relates to debt service. As you probably are aware, if the landlord spends the money that the board approves as a capital improvement, it has to be collected back from the tenants. It can only be collected back from the tenants over the useful life, the largest useful life provided for under IRS regulations. So for all of these, they're considered generically quote-unquote land improvements, and that's a 20-year number. So our application, supported by IRS documentation we submitted as part of the record, was that we wanted these expenses to justify an increase that would be repaid by the tenants over 20 years and only for 20 years. The way capital improvements work, they sunset, they stop. So essentially, this is what I call a funnel increase for a landlord. The landlord's spending the money, he's giving it to third parties. There's no affiliates involved, and that was part of the record, and the testimony was accepted by the board, and I'd ask you to accept it. That money is given to the contractor, and the tenants pay it, but the tenants are just paying the landlord back money that he already spent. And the money was spent prior to the application and gets repaid over 20 years, starting with any approval. So the concept of debt service is recognized in your ordinance. It's allowed. And I don't think there'd be any question that if my client went to Fulton Bank and borrowed this money, the debt service, assuming the number of the loan was reasonable, your ordinance caps it at prime rate plus 1, would have been approved. Your ordinance further provides that if an affiliate makes the loan, then there's also a cap on that interest rate. So the implication in the ordinance is that loans from affiliates are okay. Because otherwise, instead of saying we're going to cap the rate to make sure they're reasonable, you would have just prohibited them. Said, no, we're not going to allow the rent board to consider it. Or we're not going to allow the rent board to consider debt service. But you didn't. Your ordinance allows debt service, and it clearly allows debt service if paid to an affiliate. The question is, what is the reasonable rate, we think? Well, that's one question. And what we submitted was we looked at the time period we spent all this money, and our proposal was we looked in the middle of that time period, and the prime rate was 7.5%, so we proposed 8.5% as part of our original application. That's how we got up to $12.69 after spreading it out over 20 years. Based upon a dialogue with the rent board at the first hearing, my client reconsidered that request and took to heart some comments made by board members about that and sent us back to look at the data. And the data was that during that same time period, instead of using the midpoint, just find the lowest one. Because if the purpose of the rent control is to keep the cost down, to protect the tenants, let's be as reasonable as we can be if we're going to get debt service. So we amended the application after the first hearing and instead requested 4.25%, which is based upon the lowest prime rate charged during the 4-year period that we've been spending money on these projects, which is 3.25%. And by the way, it's from September of 2020, time period when we now have a logical disconnect because the board's saying, well, we're not going to consider expenses from September of 2020. But it doesn't matter. We're still suggesting that that's a reasonable rate to apply for this purpose.
Mr. Hanlon, since you're talking about September 2020, that's when you concede is when the work started, correct?
September of 2020.
Correct.
No, the ordinance started in September.
No, the work done on
the oldest invoice.
Correct.
So we looked at the time span when we spent this money.
Yep.
We looked for the lowest prime rate.
Sure,
And
Sure.
the cost that otherwise we could have pulled the number out of the air, but we
Sure.
didn't. We tried to tie it into the beginning of the project.
And when was the end of the project? I guess you would just go to the last.
Yeah, but I have it right here, so I
Sure.
can just tell you. Looks like October of 2023, the last paving invoice, and October of 2023 was also the last payment for the LED upgrade. So the two projects that were completed in
So
October of
the
2023.
the totality of the timeline of the work done is September 2020 to October of 2023?
Yes.
Okay. When was the loan taken out from this affiliate entity?
Well, the loan was documented after the project was complete for purposes of asking for debt service under the rent control ordinance. 'cause we think-
When was the loan taken out,
Money
sir?
changed hands in the spring of 2024, this year.
What month?
I don't have that in front of me, but it was,
Well, let me
it was
pull it up.
around the time we filed the application. It may have been after we filed the application, because we anticipated it happening. And our goal is to establish a payment schedule which is coterminous with the rent increase approved by the board. So if there's going to be an effective date, we had to ask for an effective date of, I think, August 1st when we filed back in May. If that was going to be for 20 years, that, by way of our thinking, that should be the term of the loan. It doesn't make any sense to have interest paid before the reimbursement from the tenant starts, and then 20 years or 19 years down the road, have interest stop, but the tenants are still paying it. So, and I've done this with other rent boards, too. And that's may have, have guided our decision-making here, because those other boards approved this, again, to make it coterminous with the repayment plan. But the money did change hands. It changed hands to facilitate our request for debt service. But we think it's consistent with the rent control ordinance, which recognizes that debt service is appropriate, and it's for several reasons, and one of which is that to reimburse the landlord for the cost of the use of the money that he's going to wait 20 years to get back. And the question of whether or not that's reasonable is answered by your own ordinance, which says it can't exceed prime rate plus 1. And we certainly limited ourselves to that.
So I'll represent to you, Mr. Hanlon, and just to all members of council, just so we have the background on this.
Sure.
The application by you, Mr. Hanlon, was filed on April 30th, 2024, or if we want to say May 1st, 2024, right?
Right.
It was initially scheduled for a hearing before the Rent Leveling Board for June 24, 2024. And then it was postponed by the request of yourself, the applicant, to August 17th, 2024. The promissory note for the amount of $835,962.53, with the initial percentage rate of 8.5, was dated as of July 31st, 2024. After the application was submitted to the Rent Leveling Board, and after the first hearing date that was actually scheduled, but before the actual hearing date that took place. And this is also referenced in the resolution, I believe council has,
Right.
Has the adopted resolution. I just want to get the timeline straight.
Right.
Just so everybody's
Well, again,
literally on the same page.
The loan was generated to facilitate reimbursement under the terms of the rent control ordinance. We weren't anything but open about that.
But what's the purpose of, let's be frank here, right? What's the purpose of the loan if the money was already expended, other than to add a percentage premium for money exchanging hands between affiliates?
It's not, you call it a premium, I call it a consideration for the fact that the tenants get to pay this over a 20-year life. So again, it's what I call a frontal increase. Landlord spends the money, gives it to the contractors, and getting it back, there's not $1 of that goes in the landlord's pocket. It's just a reimbursement for money he's already put out.
But he just doesn't want to wait the 20 years to get it back, and now he wants to charge an interest, again, premium, for money that exchanged hands between two affiliates, two of his own companies.
Which your ordinance allows. Again, if we went to Fulton Bank to get the money,
But you didn't.
I know that, but there's no difference in your ordinance between affiliates and third-party lenders.
I have a question. You got this loan prior to getting it approved through the rent leveling board, correct?
Correct.
Why'd you do that?
Because it had to be supported by an exchange of consideration.
Explain that to me like I'm not a lawyer.
Asking the board to approve a loan hypothetically is one thing, asking the board to approve a loan that's actually been made. So we actually had the money had to change hands. There had to actually been a loan to support the document we gave to the rent board and to you, which is the note. Otherwise, it'd be just hypothetical.
So you took the loan not knowing if it would be approved.
That's correct.
And after the first hearing date was set, correct? That ended up getting
Well, the
adjourned
first hearing,
from...
yeah, right, but the
Right.
first hearing, but again, we did it for purpose, and again, we've been open about this 100%. We did it for purposes of rent control, and we could have done it sooner.
Respectfully, it just seems like you did it to get another, let's go with the
We did
lower
get
end,
additional
4.25% added.
Yes,
Yeah.
because the ordinance justifies it.
Can I have a few, can I jump in here?
Yes.
So I just have a couple questions, and obviously this packet is a lot of information, and just to clarify certain items in the packet, I see a credit card bill, it looks like, from Citi, where it looks like certain people from the company may have access to the credit card. And I see a lot of charges on here, like, for example, Walmart, Wawa, Dollar Tree. Some of the charges, or a lot of the charges, are out in California, New York. Is that supposed to be in this packet, or?
Yes, because one line item on there might be a bill related to capital improvement. So all we asked the board to approve are the total amount of the invoices we submitted from contractors. Your ordinance requires that we also supply quote-unquote proof of payment. So there's a couple of situations there where the board raised questions about proof of payment. One is we use credit card to pay a contractor, and we gave you the entire bill to show you
Okay.
whatever else we're doing, but those charges are not included in our computation of the rent increase we requested.
Okay,
Same with, and maybe I'm anticipating your question here, we had a contractor, and I forget which one, I think it was the contractor who did the swale, who didn't pay his laborers. So a lien was placed on the job. So a lien was placed on our property because he defaulted in paying his laborers like he should under law, and like we hope everyone does. We had to hire a lawyer to get the lien off our property. We paid the legal bill. And then what we did to show satisfaction of the balance of the contract we owed him was, we didn't pay him, and I don't know what the number is, but maybe $2,800 of his invoice, and we said, here's our legal bills. We paid the lawyer more than that to get rid of your lien. Well, no, we did an offset. Whatever the lawyer cost to remove the lien, we did not pay the contractor. So the lawyer bills are there to show we actually expended money to satisfy that contract debt. But the only thing included in the computation where we were asking the board to justify the rent increase is the amount of the contractor's bills. So nothing else that might be in the lawyer bills are part of our request to make the tenants pay anything.
right, and that is another question I had. I see a lot of legal bills for liens,
Yeah.
which would not be capital improvement,
That's
but you
what that is.
explained it. So I appreciate.
The tenants weren't asked to pay an increase based upon anything other than the contractor's bill.
Okay, I can appreciate that. What happens if the loan is 4.25 and 5 years from now rates drop and Friendly Village, Mr. Temple decides to refinance at a cheaper rate?
Well,
Is there going to be a reduction for residents?
Well, similar to the board chairman asking, well, what happens if you prepay it? What we promised we'd do if they approved the debt service was file annual reports on what's happening with the loan. We agreed that that would be a reasonable condition for the rent board to approve, and if you approve debt service, we would agree that'd be a reasonable condition for you to approve. So either annual reports or changes in the status of the loan, whichever's, sooner, or both. Any such condition, keeping us honest, I'm going to use the vernacular, keeping us honest in that regard, we'd agree to any condition you'd impose in that.
But, and I guess in a sense, if he's his own affiliate, he's collecting the interest, so there would be no interest in going to a lower interest loan if it became available. So here in government, we are required to get 3 estimates. Are they seeking other estimates, or are they just going with one contractor for work that they're performing out there?
Well, your ordinance has a specific requirement for that, but it's only applicable to affiliates. So if we hired an affiliate to do any of the work, we would have had to submit 3 bids to justify the reasonableness. But that's the limitation of that requirement set forth in your ordinance. Only if we contract out with affiliates or partnerships or, related companies. And we didn't in this case. The board explored that when we answered their questions.
Okay.
But happy to answer yours.
And I guess my last thing for now, and so other people, anybody else has anything. So I guess what you're saying, in the ordinance, you guys are, hey, we're good with that, we're abiding by that, right?
Well, no, I want to be careful. It's my understanding there's a lawsuit pending challenging provisions of your ordinance. But in the meantime, everyone expects we're going to live by it. For example, we have to live by your 2% limit, which we are. So I think we're complying while the lawsuit's pending. So I just don't want to mislead anybody.
Right, and you said that you're going by, hey, the ordinance says this is the interest rate plus 1%, but you don't agree with the language that it says about the 18 months. So
Well, the 18 months language, I think it's worded poorly for the date of invoice, because that's just unfair, number one. Number two, the same sentence also gives the board discretion to waive that 18-month limit based upon certain facts and circumstances. So we're not challenging the 18-month limit. We're asking you to use the discretion that's in the ordinance to waive it under the circumstances of a paving project, which straddled the 18-month number, and under the other 2 projects because the ordinance was new.
Okay, thank you.
Mr. Hanlon, going back to the loan in question with the debt service coverage ratio. Not to quote myself, but I'm looking at the July 29, 2024 transcript provided from your office, page 115 and 116. I had indicated to you during that hearing, you would agree with me that it is in the rent leveling board's discretion to assess the credibility of any documents provided to it, correct? Your response was yes. I then replied and said, okay, and that is explicitly set forth in the ordinance that we referred to tonight, page 11, which states letter C, which states that the board shall give both the landlord or owner and tenant reasonable opportunity to be heard before making any determination, and shall base its determination on the relevant, credible evidence before it, correct? Your response said, that's the law. And then I indicated, so the credibility assessment is left up to the board in this hearing and any other hearings, correct? And
It is, but
correct.
But it's a discretionary decision.
Sure.
And it can be abused. And we're suggesting it was wrong.
So,
We're not reviewing their report.
Sure, exactly.
We're asking you to exercise the discretion.
I'm just laying the
A, you have the
foundation.
discretion, and B, you should exercise it in our favor for the reasons I've argued.
Sure. I don't disagree with you that the discretion is there. I was laying the foundation from the July hearing, to apply it to this council as well. So you'd agree with me that per the ordinance, in terms of this appeal, it's this council's, discretion to assess credibility, correct?
Yes.
Okay. So if they were to find something as So they have the ability to determine whether something is credible or not credible, correct?
Yes,
Okay, and then make their decisions based on that.
yes.
Okay.
However, as it relates to the loan, I don't think credibility is an issue. I think the question is a loan that is obtained solely for the purposes of being able to charge debt service reasonable under the circumstances? Because there's no question that how the loan document was prepared. We said
Sure.
we prepared it, and nobody seemed to raise the question that the money actually changed hands. So I think the facts are the facts. Question is, what's the policy that should be implemented? I think, how do you apply your ordinance to allow that or disallow it?
But it's within this council's discretion to determine whether it was reasonable or unreasonable for that loan to have been taken out in the way that it was.
I think that's the decision. Yes.
Correct?
Yep.
I just, this is more of a learning exercise for everybody here as well, to understand what's in their discretion and not.
And I should be clear in my argument in that regard, so I appreciate the question.
Anyone else have any comments, questions? Can I just ask for like a 2-minute break? I mean, everyone will stay as is. I just need to use the ladies' room.
No. Yes, of course.
Yes. We don't want to say no to that.
So, Mr. Hanlon, we've covered the 18-month and the loan issues. I just want to circle back to one of the first portions in your letter, which I believe it's the third paragraph regarding the tenant-weighted rent board.
I had to make that argument for the record. That's an objection to the contents of your ordinance.
Sure.
You can't do anything about that.
Understood. I just want to set the record clear and make sure that, I'm addressing the concerns of, any possible concerns of counsel who might be reading this letter as well.
Okay, sure.
You indicate that you reserve the right to pursue legal actions, which I think you just indicated on the record as well. And then there's a sentence that says, on the other hand, should counsel grant relief to the landlord as part of this appeal, the procedural due process infirmity created by this tenant-weighted rent board will be cured. What was the intent of that language, sir?
Just pointing out that, so first of all, I believe the tenant-weighted board, so everyone's focused on this. Your rent board is made of 5 members, and 2 are tenants, and one landlord, and then 2 non-landlord, non-tenants. We think that violates both procedural and substantive due process rights of the landlord. And I'm litigating this as we speak in Toms River, Manchester Township, and that's scheduled for a hearing on February 6th. So I briefed it. There's no case law precisely on point, I think, because most people figure out you can't do that, but put that aside. But it's, to the extent that it's a procedural due process issue, what the law says is it's not cognizable as a claim. I hate to use legal phrase, but you can't act on it where it's meaningless if you have somewhere else to go and get the decision fixed. That's as simple as I can explain it. That's the United States Supreme Court case, which says even if there's a violation of your procedural rights, you have no claim if you can get it fixed somewhere else. So if I have a claim that that 2 tenants on a rent board is unconstitutional, and they deny part of my application, and I come here and you approve it, my claim becomes worthless. That's what that means.
Okay. I appreciate
So I just
that.
wanted to add context to that. It made sense to me to make that comment, because otherwise, if I just say your ordinance is unconstitutional, but hey, let's talk about fixing the rent increase, someone may say, why are we bothering if this guy's going to sue us for procedural due process rights?
And not to get into it, but there's already pending litigation in regard to the constitutionality of this leveling ordinance, correct?
There is, and now what gets added to it is an as-applied claim
Okay.
with dollars associated with it, because on the other case, as I understand it, is a facial contest to the constitutionality of the ordinance. Two different causes of action.
So if this council were to not approve any additional increases, you'd be seeking monetary damages?
That may happen. I mean, it depends on the results, because we are talking about, for example, the stormwater drainage is $15,000, and if I just focused on that alone, it would probably be less than a dime in a rent increase spread out over 20 years, the same with the other, the shuffleboard court. Obviously, and, despite the fact that we may say we're right, you're wrong, there's practical effects to all litigation. My clients pay a lawyer, and at some point, so I don't know how the result will be evaluated. For example, I think the most significant issue relates to the paving. I was just doing some math while you took a quick break. Of the paving expenses, we can't cure, no matter how fast we acted. If we filed the application the next day, we can't cure $70,600 of what was omitted from our repaving project by the rent board because of the time of the ordinance. Those were so old, but still part of the same project, we think, and submit. If you were to reverse that, that would be the bulk of the application. And I'm not negotiating here, I'm just answering your question.
Sure.
My client may say, okay, I'm done spending money at this point, rather than chase a nickel or a dime.
And how much is that
For
per month?
example, I don't know, I didn't do the math separately, but hold on, real quick. 28104. Okay, so the repaving project alone, if that were changed in our favor, it would be another $2.04 per month per site.
$2.04?
$2.04, no debt service. I'm just giving you principal amount.
Sure.
And I'm just trying to give you perspective for my last answer. If you denied the swale improvement, it's 11 cents. So, again, I've had clients, I'm not saying what Mr. Temple will do, I don't know. I've had clients who basically told me, I'm not paying you to chase 11 cents. Even though it's $15,000 over 20 years, it's $15,000 over 20 years. There's some people who won't want to litigate for that. So I don't know what my client will decide to do concerning what decision you make. And I don't want to think about that tonight. I just want to think about this decision and asking you to approve what we submitted. And if you did, again, the ultimate result, the board approved $3.81. And that's been implemented, it's my understanding, January 1st. My client sent out his rent increase notice on your ordinance. And by the way, we postponed the implementation of the 381 so that we could dovetail it with everything else, because they did a 2% increase. There's a $1 utility increase, and I think 59 cents in taxes. He did it all at once, January 1st. If you were to give us everything else we asked for, that would represent an additional $5.24. Just to give you a perspective of these issues. That doesn't seem a lot. I mean, that's $5.24 for 572 units over 20 years is a lot of money to my client. That's worth pursuing. The other side of the coin is, and every penny is important to the tenants. I don't want to disregard anyone's concern out there. There's people at fixed incomes, I get it. I don't want to be callous to them. But the other side of the coin is, it's not a tremendous wallop to anyone for the if you were to approve the $4.26.
I have one more question.
Please.
Do you have your packet in front of you?
I have, do I have what?
The packet.
I have everything.
All
So
right. FV page 20, on the top of one of the
there
invoices.
was, let me just catch up to you, okay?
Take your time. From Swift and Son, it's an invoice.
20?
Yeah.
Thank you. Go ahead.
The date is circled, and it says, "Just received now. If this date is an issue, let me know." What's that supposed to mean?
I have no idea because the ordinance wasn't even,
Well, my question is what would it, obviously, dates are very important right now with this hearing. So why getting a copy or an invoice from a company and somebody circling, is this date an issue? If it was an issue, would that date have been changed, is my question?
No, I'd have to talk to, no, it wouldn't have been changed.
Well, we don't know that for certain, do we?
Well, no, I mean, I wish it would change. If we're going to change it, we would have had this included. This was excluded. I suspect, hold on a second. I suspect this is, I'm guessing. You want me to guess?
No, I don't want you to guess. I'm just raising you don't need to because it doesn't matter. It's a credibility with these dates is my question. I just wanted to get that on the record.
I don't know the answer. I'm going to guess anyway, just, you told me not to. It looks like we say it was received in the following tax year, okay? So there may have been an accounting issue with that.
Okay.
I don't know.
So this is just my assumption, Mr. Hanlon, but and based on what we left off with in terms of, maybe it's, there's different considerations to be had with the debt service or the 18 months. I think there might be further dialogue needed, with counsel and yourself and your client. When do you anticipate a decision by?
Well, your ordinance is silent on it. I think you have a reasonable time to consider. It's a large packet of information. Someone up there said, I need more time to read this. My response would be, great. I want you to read it. I think it supports our case. And just like with the rent board, when you said, what deadline do you think we have?
Right.
The answer is, I'm not going to give you the deadline. I think you should act reasonably. And that went out another month, and we all worked together, and it was fine. So I think I would expect the same thing. My experience with Monroe Township has been nothing but professional, especially with you. So if you need additional time to give consideration to something, I'm not going to object to that. What you tell me what you need, and I think the answer is yes.
I don't know if anyone from council would like to chime in. I know our next meeting.
Plus, I've been doing this long enough to know if I press for an answer, I'm likely to get it I don't like, so.
We try to work fast, but we also like to do our due
I get
diligence,
it.
so I'm sure you can appreciate
Yeah,
that.
I would like to look this over
I think-
for us so we can push it,
Right.
definitely not tonight.
I think you're giving yourselves this job, and the ordinance is ridiculous. You've got too much to do to comb through these type of documents. I understand you want to be responsible, but seriously, my experience with, I'm going to be very gratuitous here. I've been doing this for 40 years. In some towns, I've worked in the towns for 40 years. So I basically know the history, and my experience with most towns is they adopt ordinances providing for appeal to the council, and after about 2 or 3 appeals to the council, they say, let's amend the ordinance, go to court. But whatever, you'll make your own judgment call.
I know for a fact council is taking this seriously, and I know they, as late as it is, they intentionally put that appeal to council in the ordinance so that obviously they could get the opportunity to review what's before them. And, on the record, I know you and I had exchanged emails about the potential to not come straight to council based on potential ambiguity in the ordinance. And I had indicated that I think it might be best to come to
Well, we're
council.
here.
So, yeah, exactly. And I appreciate your willingness to come present to council, and put everything together. Our next meeting is February 12th. I'm sure we will have, some discussions in the meantime, Mr. Hanlon. And I'll follow up with, Council President in the next few weeks, in terms of getting hopefully a resolution in the February or first March meeting.
Okay, and I'll send you the case law on the open public meeting law.
I actually found it. I did my own
All
research.
right, great,
I interpret it a little differently, but
okay.
All right. Any
Any
more
other
questions? Thank you.
Thank you for your attention and focusing on this.
it's Accardi versus Mayor and Council of North Wildwood.
That's it.
Moving on to general public discussion. Do I have a motion to open to public portion?
Motion.
Second.
In favor?
Aye.
Opposed? Anyone wishing to speak this evening? Seeing none, do I have a motion to close public portion?
Motion.
Second.
All in favor?
Aye.
Motion for adjournment.
Motion.
Second? All in favor?
Aye.
Adjourned.
Have a great night, Mr. Hanlon.